Eichmann, which also involved flag burning, should have been decided as it was? Did it follow exactly from Johnson? Or is there a constitutionally significant distinction between Johnson and Eichmann? What do you think?
Hello, my name is Larry Dubin, and I'm a law professor at the University of Detroit Mercy School of Law. Every day, I, like all the other law professors in this country, rise to the challenge of teaching our students about the law. Teaching law is a solitary experience, and yet there's a lot that we can learn from one another. So I decided to make a program where I would visit the law classes on a given day of other professors at my law school. I interviewed the professors before each class, and I met with a number of their students after their classes. And what you will see in this program is another routine day in the life of law professors.
Okay, today we're talking about punitive damages. Can punitive damages be awarded in a contract breach? And we're looking at one particular case, the Siemens case, which is coming out of the California Supreme Court.
It seems like every day we start out with usually like a 10 to 15 minute summary of what we've discussed in previous classes, and then also to set, I think, the foundation of where we're going in this class. I think it's helpful because you get an idea of the big picture and then also where you're going.
She usually has overheads and points it out to us, you know, what to look for, what we should be looking for in the cases. And then she'll go into calling on us.
A lot of times we jump into cases and students don't realize the significance of the case because we don't have the luxury of reading the 4 or 5 cases which came before that particular case. So in the few minutes at the beginning of class, I try to set up the case by going through some of the historical material and some of the conceptual material. The case we have for today, the Siemens case, is a little tricky, and we need to go over some background material before we understand the context of the case. Because today we're going to be looking at the intersection of tort law and contract law. Today we're going to be looking at when does contract law meet tort law in terms of the types of damages which are available for an injured party to a breached contract. So we need to step back a little bit and be conceptual and think about, well, what are some of the differences but also similarities between tort law and contract law, and why traditionally there has been a so-called wall of separation between tort law and contract law.
Professor Zito usually asks the type of questions that you can answer. It's nothing that she doesn't look to trick you, but she looks just to get points, specific points out of cases. And she usually tries to help you as much as she can.
I guess her effectiveness is that she's very thorough with each case. We, you know, sometimes we'll have several cases in a class, and she'll have to rush at the end. And sometimes, you know, at the end of the class you'll get disturbed, but she'll always take time out the following class to make sure that you know what's going on in that previous case.
I think professors design each class to try and teach you a specific point or specific concept of the law. And if you walk out of there saying, I don't really understand why we had this class or what was so important about the elements that we discussed today, that sometimes leaves you with the feeling that you're lost or that you're not getting the information that you need. But when you walk out of a class and you know exactly why she mentioned the things that she did or why she made the points that she did, then you have a firm understanding of why you were there at all that day. And you feel good about yourself if you can do that, I think.
I'd say it's very effective because when I went back last semester to study my notes, the things that she put up on the overhead and the things she talked about before class were most of the things that I took and put into my outline and studied from, and I ended up doing well on my exam.
But I think she's aware of whether or not we understand what's going on, simply because I don't think any student would hesitate to raise their hand or stop her if they didn't get what was going on.
I guess I base a lot on eye contact. So while I'm talking to them, I'm constantly looking around the room and looking into their eyes, looking into their body language, and I can tell if they're paying attention, if they're interested, if they're concerned, if they care.
I might feel more comfortable in this class than other classes because she tends to stay focused on what these particular cases deal with, and doesn't make you really feel intimidated as far as standing up or participating in class. So I don't, other classes, you're put on the spot, you're asked to give opinions that you haven't really studied anything on.
I think back to what happened when I was in law school. I hated being called on. The times I was called on, I felt like it wasn't a positive exercise. So I'm trying to see how can we make being called on a positive exercise.
The more you're willing to participate, maybe the more you're willing to analyze in your own mind things in a way that you can prepare them to speak in public or to speak in front of class. But I think the whole idea of comfort, it looks the way that you perceive the class. If you're more comfortable with it, maybe you'd like the subject matter better. You'd be more willing to prepare for it.
I think it's a good class when, just by the nature of their answers and their questions, I can tell that they've caught the gist, the framework, the main points of the material that we're supposed to cover. If they're listless, if they're not paying attention, then that's not a good class.
I come prepared to this class more so than other classes where I'm not going to get called on or I'm not going to be participating, and more apathetic towards doing my homework.
I think the ultimate goal is that, and this is not always achievable, is that each classroom session should be scintillating. I mean, it should be absolutely exciting. It should be stimulating. People should want to be there. They're not there just because they have to be there. They should want to go to contracts class. They should want to do the reading, and ultimately, they should want to be called on.
The course is a First Amendment course, and today, because we're coming to the end of the semester, I will be covering more material than I usually do. We'll be starting off talking about symbolic speech, flag burning, and then cross burning.
Phil Donahue comes to mind from the first time I saw him. That's what we thought, Phil Donahue. He walks around every day with a mic, and he talks to people, and he gets up close. He doesn't stand behind the podium, and he honestly wants to get your opinions and your feelings. And he intentionally calls on people that don't raise their hand because he would like to hear from them, and he's interested in what they have to say.
I wouldn't characterize it as a Socratic method in a strict sense. I regard it as a conversational method. That is, I don't feel particularly bothered by having to answer a question or by perhaps laying out a summary if it strikes me to do that. But I try to create a conversational mood in the classroom so that while I'm thinking, they're thinking.
And I think his style is fairly effective, definitely. I mean, it's much more interesting in this type of class for him to open it up for discussion than to simply lecture because, constitutional interpretation it varies so much.
This method enables me, I think, to bring the students to the cutting edge, to the gray areas, and have them explore those gray areas. There's no point in telling students that it's a gray area as distinct from letting them explore what a gray area is. So it's experiential in nature. I think that students learn the process of being critical legal thinkers through the method that I employ, if it works.
I think it's a good tool because it seems to go through the cases in a way that's interesting, as opposed to having them, stand up there and say, well, this case said this, and here's the holding, and, go and use it.
Of course, they'll be thinking about the questions that I pose. Hopefully the questions that I pose, or maybe even just one question, will be sufficiently obscure and marginal so that it will encourage students to challenge me or to challenge each other or to jump in with a particular point of view.
He walks around the room. He makes eye contact with every student, and he talks with every student. He talks to them. He doesn't lecture at them, not like a remote crowd. Or I even have instructors that look at the ceiling when they lecture because they can't even look at the students.
It could very well be intimidating because if things are rolling along well, then I don't stand up at the lectern anymore, and I start wandering around the classroom and speaking to students in the same way that I'm speaking to you, as close as this, if not closer. So it's possible that a student will feel intimidated. I wouldn't doubt that some students do feel that way. But others, I can tell, engage me. There's eye contact. There's a real personal involvement that's taking place in many instances. Why doesn't the burning or the destruction of the flag involve merely conduct?
Well, it does involve conduct.
It does involve conduct, clearly, as would be the case with most, and I would say all speech. Okay.
But the conduct has a communicative element in it, and that's what they're regulating.
And so Justice Brennan looks at that communicative element?
Yes. That the interest is directly, the governmental interest which is asserted is directly related to the suppression of expression.
And what if it is?
Usually I get nervous when I'm first called on, but then after about 20 seconds, 30 seconds into it, I get more relaxed, and then I enjoy being called on. I enjoy being asked questions. But initially, I'm nervous.
For all the students, it makes sure that they're paying attention, which is probably one of the reasons he does it, but it also means it's his nonverbal way of telling you, I'm interested in you, I'm interested in your opinions, and I'd like to hear what you have to say. And so it's a very positive environment. But that's not a threat to national security. And I think you're dramatizing the event.
No kidding. I didn't realize I was doing that. But all right.
He cares a great deal about this subject, and I can't fault him for that. As a matter of fact, I applaud him for being so interested in this subject. He obviously reads all of these cases and hangs on every word. Whether the ideas expressed by the conduct can really be separated from the conduct itself. And in this case, it's rather difficult to do that. I mean, maybe the state has a right to prescribe.
One more try.
And I think people's opinions have changed because they really don't know why they have an opinion that they have. And that once he gets into the, why do you really have this opinion, that people think, wow, I never thought about that, why I have this opinion.
I insist that students are there, so they sign an attendance sheet when they come in. I pick people at random. And people also volunteer. So it works both ways. They have no idea who I'm going to pick. There's no order to it. And frankly, I don't know before I go in who I'm going to call. I might call someone because the person has been too quiet all semester, or I might call someone because I know that their point of view is different than my own.
I have discussions actually with students in that class about whether that style is effective or not. And there are some who argue that you have a right to come to class prepared or not prepared, and you have a right to pass, and you have a right to not be called on. And I guess my argument is that it fosters you to be prepared, knowing that you could get singled out that day. And I think that's good.
He doesn't like it if you're not prepared. In fact, he doesn't tolerate it, so. Other than that.
What's your reaction?
It should be that way because the class is more interesting.
I'm a lawyer first and an academic second, and the image in my mind is of a courtroom where you stand up in front of the judge and say, "I'm sorry, Judge, I'm unprepared, my car broke down, it's raining today, I forgot my umbrella," so forth and so on, which is preposterous. And so I'm attempting to instill in the students a sense of strict accountability and responsibility for the obligations which they assume. Their obligation is to be prepared, and I feel that I owe it to them to not let them get away unscathed when they fail in their obligation.
They weren't in this case to challenge the law specifically, as opposed to Johnson, where they were protesting policy.
So what difference does that make?
Well, I guess maybe, although they both are political, the second sense is maybe not the political attribute that they were trying to get at. I'm not sure if it has a difference, but it seems like it should. Because I don't like talking in class. Even if I know what the answer is, it just, the potential of being wrong is something I still haven't come to grips with. And I know that the class setting is the place where you're supposed to work those things out. So when you get out in, the real world and have a judge screaming down your throat, that you can deal with it. Because the classroom setting isn't nearly as hostile as what I imagine a courtroom setting or a job setting will be like.
I'll know because I'll be comfortable in my thinking process. I'll be thinking and learning along with them, and I'll sense that they are thinking and learning along with me. I'll know that by the kinds of comments and questions they make, and by the kinds of comments and questions I make. And that's how I'll know. It doesn't always work out right, needless to say.
We assign them thousands of cases to read in law school, and they kind of zip over them, and maybe a professor calls on them to describe the facts, but they don't really think about or understand the facts. And the first part of today's lecture is designed to sensitize them to what the facts really, to what the very summarized version of the facts that you read in appellate opinions of the court could really mean in a violent, murderous, tragic situation. Homicide! People versus Morin. Sandra, you assist me in presenting this case? Will you assist me in presenting this case, please? It's in your supplement? Had an opportunity to read it?
Go ahead.
All right. What happened in this case?
This is pretty typical Keenan style teaching. He wore a costume today, a mask, the Grim Reaper, and he brought in some props, I guess you could say, the axe and the knife and some other things. And he doesn't do that every class period, but he does that probably every couple of weeks, brings in props or dresses up or something along those lines.
I suppose the primary risk is that some student will get offended. On the other hand, the way you win is to take risks. And my personal view is that law school is a relatively conservative place, as it should be in many ways, that the style of law teaching can be somewhat conservative and somewhat dry, and that when there is a topic that is inherently, stupendously interesting, after all, blood, guts, sex, gore, and death are interesting things to talk about, that you should take full advantage of the opportunity.
He always has a discourse going on throughout the class. I mean, he He never lectures, just comes in and lectures. There's always someone who's being called upon to stand and recite. And they're always standing, and he throws questions constantly all the time.
And of course, it's hard not to pay attention in class when somebody comes in an outfit like that or chops off part of the podium with an axe. It tends to grab your attention.
It's effective, number one, because it gets people to read and read the material and do the material. And criminal law, I think, is so fact-oriented, and you really need to go through the facts and understand the elements. So by the threat of being called upon to stand and recite, it forces people to pay close attention to the facts of a case.
They do not know they're going to be called on in advance. I don't know what the rule is if they weren't prepared, because they are prepared in my class.
I think it's pretty essential to your learning, the law. And the reason is because you need to learn how to think on your feet. I mean, at least if you're interested in litigating.
A large part of what we do is entertainment. The secret to much of this, my personal view is the secret of a good deal of teaching is lack of inhibition. And it's not a show for the sake of a show. It's a show for the sake of maintaining attention and interest and participation.
Today, for instance, he was theatrical, but we still dealt with the one case, and we went on to describe later the elements of manslaughter, murder, et cetera, et cetera. So we certainly covered the substantive material as well.
Yes, you just said the answer. Malice aforethought is the mens rea for murder. All murders got to have malice aforethought. Are some murders unintended? Had a 50-50 shot, Hershar. Are some murders unintended? Yes, they can be. But is malice aforethought still the mens rea for those unintended murders? And the answer is yes. All right? So it's always malice aforethought, and it turns out that now I'm getting you confused, am I not? Yes, and this is troublesome because this malice aforethought stuff has been confusing people for a long time. In fact, no less an authority than Perkins on criminal law tells us at note 15 that the phrase malice aforethought used in defining murder peers at us like a demon through the dust of more than 400 years of history, lying in wait to clutter statutes and confuse juries, not to mention give first-year law students serious fits. Do you agree with what Professor Perkins said there? Yes.
If a number of students have talked, if they keep on talking after the class, if they keep on arguing and talking amongst themselves and discussing it, if they have a whole lot of unanswered questions that they want answers, and to which they want answers, I figure it's a successful class. If thinking occurred as a result of what we do in there.
We are doing in this class several role plays in regard to legal negotiations with one partisan negotiators, and today we are at that stage that we go further to the multi-partisan negotiation and to the team negotiation. For purpose of this exercise, we have quite large delegations. In fact, it would be not that large. We are now 3 days before the trial. Both sides have certain interests to avoid an outcome, a decision by the court. If they can find within the next half hour a settlement, an agreement here that they negotiate, then it would be in a certain interest of both parties, but it's not guaranteed that they will find this kind of agreement. Maybe the decision is left to the court, finally. We will see.
I think he's more of a facilitator than a lecturer or a teacher. He's there to facilitate our thoughts and our ideas.
The main purpose of the class is that the students can make a development, can improve their own skills, negotiating skills. So, and a major part of my method is practicing role plays, videotaping again.
We learn a lot in the class, but it's mostly the interaction that you're learning from, and he's just sort of the moderator and making sure that everything is flowing the way it's supposed to flow. as opposed to an instructor.
There is no chance really to stay in this seminar passive over the whole semester. I mean, it might be in one class session that the student is more at the side, but overall the students, they are involved.
Well, I think we're realistic that we have to come to some kind of a solution here, at least we hope to, and I think there's just numerous points that we should start going over, and maybe we can reach a compromise at each point, and if not, then we'll take the consequences, trial or something like that. Where should we begin?
Suggestions? After so many classes where you just sit there and you're reading the book material and learning, well, this is what you should do in this situation, you should do this, and trying to remember all these without the actual hands-on experience is always difficult, I believe. In this class, you read it and you walk into class, there's an exercise, and you actually see how the concepts work.
But it is nice to have a class where you're up thinking on your feet and discussing. It sort of rounds things out better. So this is the only one that I've had. And I would have liked to do it a few more times.
So what would you like us to do?
I think what we'd like is we would agree to buy the Techniclean, but we also want a subsidy from you and a guarantee that if the Techniclean doesn't work, that you'll replace the Techniclean with the road group.
Your thinking is sort of similar with ours along those lines. We understood that you might need some type of assistance, and actually we have discussed that, and what we prepared to do is that on the condition that you would buy the Techniclean scrubber, we would guarantee that if it were to fail, we would guarantee that, so you wouldn't have to deal with that. But we would need you to absorb the cost of the Techniclean in order to guarantee that for you.
I am definitely at the point of law school where I'm really bored. I'm tired of it. I feel like I've been doing it forever. And this class keeps it interesting for me. It's different, and it keeps things, it keeps a variety, and it's a nice way to kind of end out my years here.
In the traditional law school class, there's a lot of competition. You're working solely on your own, studying and seeing what you get out of this. Where this class, you're working together. You're working with different students, and you're the adversary of a student one day, and you're the partner the next day. So there's more trust, more companionship maybe.
I teach evidence, and tonight we're going to begin with Rule 404B, prior act evidence or prior bad act evidence. Generally, I use the Socratic method. I ask students to stand and recite. I usually use problems which come out of the text that I use, and I ask them to repeat the facts of the problem, and then I ask them questions that arise out of the problem, and then I use hypotheticals, turn it around. Every once in a while we get off into policy discussions. We may well do that a little bit tonight. And when did we say in criminal cases that this trait of character is a specific element of a claim or a charge or a defense?
When would that happen?
Yes.
Basically, in a chastity case would probably be the only time that...
The answer is almost never, right?
Almost never, yes.
Almost never. All right.
A lot of times he has us argue back and forth, taking a prosecutor's role or a defense role and just making your argument. And since I'm going into criminal practice with any luck, I really like that kind of experience.
Evidence is probably the most interactive course in law school, in that it gives students an opportunity to stand up and play lawyer. I often ask the students to argue as if they were arguing the evidentiary point, and then I ask another student to stand up and oppose that evidentiary point. And the course simply lends itself to it.
It's up to date and it's fast paced and there's a lot of participation. You know, it's not stale and old and just book cases. You know.
It's a small class. We've got probably 25, 30 students in there. There's a pretty good chance you're going to get called on, and I think you don't want to look stupid not knowing the answer, so people get prepared. I think people do read the materials, and I think in a lot of classes where it tends to drag and the professors aren't as demanding, people don't read up. And where I'm not ready tonight is allowed, it drags the whole class down.
I enjoy Professor Rosen very much so because he makes the class a very active process. And for an evening student, it's important to have that kind of motivation, because when you work all day long and you come in the evening, if you're sitting through what's basically a lecture only or called on infrequently, it's hard to maintain your motivation from week to week.
I think he's very interactive, and he's very encouraging. When you have to stand up, he always says something nice after everyone.
He knows that we don't know everything, and he doesn't like keep at you, and so you know that you're not really going to be made to look bad in front of your classmates. So you just basically say what you do know, and then he'll help you along or move to somebody else.
So why is it probative? Why are these prior acts that Rhonda Smith is talking about probative of his intent to deal in this case?
One suggestion I could make would be that those prior acts, they were completed transactions, where delivery was actually made. And here, there was a belief that that was what he intended to do in this transaction, was to actually, bring the purchaser there, then actually complete delivery, and then collect the money after the drugs had transferred.
Put it another way, what is really at issue here, given his defense?
His mental state of mind.
His intent,
yes.
Right? He says, hey...
His mens rea, actually.
Yes, exactly. If I had to pinpoint one failing that I thought too many law professors had, too many of mine at least, and at least for me, with my limitations, it was that too many law professors were academic and were not, although obviously very knowledgeable, were not particularly apt at conveying the information in readily understandable notions to what are really lay people, students who have no understanding of the subject matter.